Hi, I'm Chris Oplensky, a Managing Editor at BLR. Welcome to BLR's HR Compliance News Update. In each episode of this video series, we'll go over new and important developments you should know about and provide insights beyond the headlines from our team of HR legal editors. The most significant recent development occurred February 5th, when the U.S. Department of Labor issued a final rule for the Family and Medical Leave Act that will change the way in which covered employers administer family leave for service member caregivers and employees with family members in the military. Today, Susan Schoenfeld, a senior legal editor at BLR and an expert in the area of employee leave, is going to provide us with some details on these final regulations. Hi, Susan.
Hi, Chris. That's right. It was a surprise birthday party for the FMLA on February 5th, 2013, exactly 20 years after the FMLA was signed. The U.S. Department of Labor issued a final rule ahead of the planned regulatory schedule. Now, this 6-week early surprise issuance of the regulations was a surprise to employers, but the content of the rules themselves were not really a surprise. The final rule amends certain FMLA regulations implementing amendments to the family military leave provisions of the law that were made by the National Defense Authorization Act, or NDAA, for the fiscal years 2008 and 2010. Now, to implement the NDAA's amendments made to the FMLA, the final rules amended the FMLA's qualifying exigency provision. And in the final rule, the FMLA regulations are revised to reflect the expansion of the qualifying exigency leave provision to include eligible employees with family members serving in not only the reserves, but also now in the regular armed forces. The revised rules also add a foreign country deployment requirement and increase the length of time that an eligible family member may take for the qualifying exigency leave for reasons of rest and recuperation leave. That amount of time was increased from 5 days in the old regulations to up to 15 days for rest and recuperation. Now, the service members' rest and recuperation orders will specify precisely how many days are being granted, and that is the number of days that the employee would be entitled to. Finally, for the purposes of qualifying exigency leave, the new regulations create a new category for parental care. Now, the parental care is actually to be taken for the parent of the qualifying service member. So, for employers who are trying to determine whether or not an employee qualifies for this type of qualifying exigency leave, they would need to determine, first of all, that the employee has the appropriate relationship with the service member, and that the person to be cared for is indeed stands in a parental capacity for the service member. So, for the next category of changes to the FMLA regulations, we look at military caregiver leave. Now, under the FMLA, the final rule says that, specifically defines what conditions constitute a serious injury or illness for a current member of the armed forces or for a covered veteran. Prior to the issuance of these final rules, it was unclear precisely what would constitute a serious injury or illness. So now that the Department of Labor has cleared that up, as of the effective date of the rule, March 8th, 2013, employees will be entitled to take leave for covered service members with a serious injury or illness. Now, the new rules also expand the definition of serious injury or illness to include not only existing injuries, but pre-existing injuries and illnesses that were aggravated in the line of duty. The new rules also add enrollment in the Department of Veterans Affairs Program of Comprehensive Assistance for Family Caregivers as evidence of a covered veteran's qualifying injury or illness. And finally, they allow private physicians outside of the military healthcare system to certify a serious injury or illness. This is particularly important for both active service members and veterans who have turned to their family doctors or their private doctors for treatment. The Department of Labor pointed especially to service members or veterans who are suffering from post-traumatic stress disorder and go to their own doctors rather than a doctor within the military system. Now, the final rule also includes clarifying changes concerning the calculation of intermittent or reduced schedule FMLA leave. The new rules also remove the forms from the regulations themselves. Department of Labor has made a decision to include the forms and certification documents in an online site on the dol.gov website, and also made them available through the Wage and Hour Division's regional offices. So employers wanting to obtain the most recent copies of the DOL's FMLA forms should go to the dol.gov website or to their regional offices for the Wage and Hour Division. Finally, the final rule amends the regulations to implement the Airline Flight Crew Technical Corrections Act, which establishes eligibility requirements specifically for airline flight crew members and for flight attendants. In the past, the FMLA leave provisions were tricky to apply to folks who work in the airline industry. Now the DOL has issued regulations regarding the calculation of leave for such employees, as well as special record-keeping requirements for their employers, and hopefully clarified some of the questions that were out there, and also made it a lot easier for the airline industry to address FMLA needs. As I mentioned before, the provisions that aren't already in effect for the FMLA will become effective on March 8th, 2013. So in the meanwhile, employers should be looking at their FMLA policies and making sure that they are using the most up-to-date terminology for family military leave, and also using the appropriate revised forms and notice forms, which are available on the DOL's website. Thanks, Chris, and back to you.
Thanks, Susan. To be notified when future installments of BLR's HR Compliance News Update become available, subscribe to our YouTube channel at www.youtube.com/BLRinc. For BLR, I'm Chris Oplensky.